today's sessions on intellectual property rights. In today's session, I will be talking about how to set up an IPR cell in an engineering college. And this session is actually a continuation of our earlier two sessions, in which we actually covered the reason why IPR is important for engineering education and why an institution should make a policy regarding IPR. So in the first session, which I did about 15 days back, I covered intellectual property rights. What do they mean? What is their significance in the context of an engineering education? Today, all engineering educations are technical in nature, so they will be conducting a lot many R&D projects. People will be doing PhD students, will be MTech students will be doing projects, and all this context have actually there's a chance of a creation of the discovery of an IP or intellectual property, and this intellectual property has become an engine of growth and wealth creation in knowledge economy. For that reason, every college, every engineering college must identify that intellectual property is an important thing. And I also covered the different types of intellectual property, starting from patent to copyrights to design and all. So once that was done, and the following session actually I covered a model intellectual property policy for engineering colleges. As you know, actually, when you run an institution like engineering college or even a business and organization, you have to have a policy for doing everything. For example, if you are recruiting people, then you have a recruitment policy. And if you want to retain good people, then you must have a career advancement policy. Similarly, you should also have an intellectual property policy that would actually create an ecosystem within an institution, which shows that the institution is very serious about intellectual property, and it also identify all the stakeholders within its system, and it will also state out the procedures and policies on how actually intellectual property is viewed within the institution. What is that institution is doing about maintaining that or creating that, or how do you go registration about? Okay, so that was covered in the second session. So now I come to this particular session. So this particular session has a single purpose. It was going to provide you initial inputs and guidelines for setting up an in-house IPR cell in an engineering institution. So by in-house, I mean it is setting up a kind of an office within your institution, which will be concentrating on IPR issues within an organization. It is like, say, setting up a sports cell within a college, or it's like building a hostel within an institution. So it becomes a part and parcel of the institution. So in order to look out at all the requirements of an IPR activity within an institution, you are separately creating one office. It's called in-house. The reason why I'm presenting this is actually in my college, in SDM Engineering College, Dharwad, I recently set up an IPR cell for my college. So who are the audience I've been looking at? Actually, I'm looking at different audiences like decision makers, like management, heads of institutes and deans, and also the executives like IPR cell in charges, Dean R&D, because in most of the institution there will be a role called Dean R&D, and the IPR cell actually comes under that. And the stakeholders like faculty, students, and researchers. The reasons these are interested because faculty people either doing a PhD or guiding some projects, there is a potential chance of creating IP. Students, as you know, when they are doing their MTech projects or interacting with other agencies and all, there is a chance of they creating an IPR. Researchers, of course, they have a high potential. Hence, I intend to address all the questions open to this audience. Okay, so the first question that you ask me, like, why do I should set up an IPR cell at all? So there are several types of intellectual property which a college may wish to pursue, because I told you in the context of R&D and research, and also pursuit of research, PhD from faculty, and also this one, there is a chance that somebody may end up with creating a patent or utility model or industrial design or trademarks, copyrights, such kind of a thing. So there is a great potential and a great situation in which an IP can be created within an institution. For that reason, and to maintain that kind of a thing, you need to set up an IPR cell. So when I say IPR cell, you know probably from my previous classes, there are two kinds of IPR cells. For example, those which need registration like patents, trademarks, design rights, domain rights, and plant breeding rights. Non-registered like trademark, copyright, and database. Okay, but our focus of an IPR cell is all about on the left side. That means especially patent. Rest of the things actually more or less actually industrial kind of a thing. You rarely have a chance where actually a trademark is created or in the context of an engineering education. But patents, they are the regular features if R&D is actually happening at a great speed. So the first question that we'd ask, like, what do I need if I want to set up an IPR cell? So normally I need people who will be looking after that. We also need resources and extended resources, because an IPR activity is actually goes beyond the institutional boundaries, because there will be a funded agency which will be operating or which will be funding your research projects, or there could be a researcher who is visiting to you. So it goes beyond that. And you also need partners, because IPR is not an isolated activity, and there are a couple of activities that also happen within this context. Okay, now let me start with patent procedures. Of all the IPR, actually, the IPR cell would be interested in patent procedures, because other things like copyright, design, industrial design, and all, they very rarely happen in the context of an engineering college. So let me look at the patent procedure. So patent procedure will involve the following steps. The one is actually, if and when there is a requirement, somebody will make a patent application. So this is the first step. Okay, there are certain steps before this, but that I will cover later. So if you are going for a patent from an IPR cell, then there is a thing called patent application. And there is a publication. That means you apply to a patenting authority, and they will publicize it saying that there is an application regarding this. And there is a chance given by this patent office to the public to offer any pre-grant opposition. That means if you apply for a patent, the patent officer will ask the public, is there any similar patent already given? And if the public knows about that, they can share that information. And once that is through, then there is a process where actually the experts within this patent office will actually examine the claims that you have made. For example, what is your patent is all about? What are the distinct thing? What is the novelty? And that is taken care in the examination process. And there is an application grant. Once this are through, then immediately the patent authorities will grant you a patent. That means a patent is issued in your name. And after that also there is a provision for patent office to seek any input from the public or industry and all, seeking check whether the patent which is given is actually unique, or if there is any kind of a comparison or any kind of a duplication. So normally this patent process would take anything between 3 to 5 years. So if you apply some patent, say in 2015, eventually you may get it by 2020 because of the involved process, which is very long and leading. Okay. So where does this actually start? So see, patent will start with invention disclosure. So what is invention disclosure? Assume that there is a person who has made a discovery which can be patentable. Then what actually happens is he has to enter he has to come to patent office, the IPR cell, and has to create a document which is called invention disclosure. As the name suggests, disclosure is a process where actually what is known to the inventor until now is disclosed to the authority. What is this invention? Invention is part of the patent process. So what is that written description of the invention? For example, if you invent a new bulb, then that is written here. When? Before publication. That means the rule which according to patent law says this, you cannot disclose your invention to the public, because if you do that, then you would lose the patentability of that. It must be kept secret until a correct procedure is followed. And how do a user does it? A researcher, by filling an invention disclosure form. Like, see, forms are a regular feature in us. For example, if you want to go to bank and borrow money, and there is a form which you will take a challan. Similarly, if you want to fill a fees, then you have to fill a form. Similarly, invention disclosure process starts with applying for a patent or invent disclosure, where actually a form is filled, in which he will fill what his invention is all about and when actually it is to be done. What is the implication? We need an in-house facility for all this above. So in order to encourage your inventors within an institution to do all this, like invention disclosure, you need a facility, and that facility is all about IPR cell. So what are the challenges do you face within an engineering college? These are the following challenges. Lack of awareness among inventors. Although there may be a good scholar, good researcher and all, he will not be knowing all the details about intellectual property rights. One, he will not know that there is a chance within his work of a creation of an IPR, intellectual property, and he doesn't know that actually institution has some provision to help him discover this and register it. Okay. And secondly, he may not even able to know the valuation of the technology. For example, sometimes you invent patentable item which might have a large commercial value. But from the academic perspective, we will not be able to find it out whether it can give a lakh rupees to you or 10 lakhs or a crore. So that is also ignorance. And thirdly, many times we don't even realize that the part of the invention or patent that we are making actually can be useful to somebody else in some other context. For example, you come out with a technological invention which can be used in an automotive engine, or you can come out with an invention which can be used in a dental surgery. So it's such a process of actually you making an invention and giving to somebody else is called technology transfer. This also many of the researchers may not be knowing. And thirdly, many people will not realize that intellectual property right is a big process which is a techno-legal in nature. That means there is technology on one side and there is a law on the other side. That also they may not be knowing. And they also may not be knowing jurisdiction. For example, a patent which is say created, generated and patented in India can used to be only in India. So this kind of a thing also people will not be knowing. And also renewals. So patents is actually given for 20 years. But if you want to retain the ownership for further, with a kind of improvement and enhancement, then they need to be renewed through every year throughout those 20 years. So these are the challenges that we face when you set up an IPR cell. So this is from the research perspective or a faculty perspective. So now I stop for interaction. Are there any questions at this point of time? So what I covered so far actually, intellectual property cell is a mechanism set up within an organization to help researchers. What does it do? It actually will help to identify patentable items and disclose that to the office so that they can process it further. So any question at this point of time?
No questions, sir.
So I proceed? Okay.
Yes.
Thank you. Okay. So now, what actually happens within an IPR cell? What is the process that would happen? So this is the process. See, a faculty makes a novel invention and is interested in protecting it through a patent. So normally a researcher or a scholar or a MTech student, while making a project or a research will think that he has made or he has come across a situation where he has made a novel invention. So invention, according to patent, is something that you have found out which other person, no other person in the world has found it. It's called novel invention. And also, as a consequence that he is interested in protecting it. That means he wants to patent it so that officially will own it through a patent. So once this actually happens, he would come to you and invention disclosure form is sent to faculty by IPR cell. The moment he approaches that, see, there is a possibility of I actually discovering something, then what IPR cell will do, it will give a form called invention disclosure form. As I showed you in the previous slide, what it considers, what is your invention and when did you do that and what is the novelty. All these things should be included in it. And once that comes to IPR cell, see, not all ideas are as good as the invented things, because when you actually screen by a third party like IPR cell authority, then you come to know that there is an invention but which will not be very useful. So you got to do a due diligence and market analysis. That means you check whether the idea which the the scholar says is patentable is worth going or not, whether it has a commercial value or not, whether it is tenable or not. So this is called due diligence. Means the authorities within IPR cell, experts, including the in-house and outside, will go through a process and which will determine whether it is worth going for patent or not. So the patent starts with a request from a scholar that he has made a discovery, and he would fill an invention disclosure form which is actually scrutinized by the IPR cell and it goes to further stage. So look at this. So what actually happens when there is an inventor? So inventor is any person who makes a research, makes a discovery. So he has to identify and define his invention. For example, I told you, if you have made an invention of an electric bulb, that you have to identify that. Or if you have made an invention of a chemical process from the chemical engineering process, that you have to say. The first step is actually you have to identify and make an invention. For example, when Google was created, they invented a new search algorithm, right? So that is what it is. And prepare invention disclosure materials for patent review committee. That means once he makes that decision that he has made a discovery, he has to prepare invention disclosure materials. That means there are certain materials which are needed. For example, when did you do this? How did you get this idea? Why do you think that this is useful? Okay. Then once that application reaches the IPR office, then a meeting is arranged between the discoverer, I mean the inventor, and the research, I mean people within the IPR cell attend the invention disclosure meeting with the patent attorney. Patent attorney is a judge, I mean it's a lawyer who is good at law issues related to patent. Review draft patent application and assist patent authority completely filling. For example, see patent I told you is a two-way process. There is a technical person who has made that invention, and there is a lawyer who is actually trying to fit within the framework of the law. So it needs a kind of a discussion or a communication between them. Assist in identifying the competitors' products and services at disclosure meeting and after allowance. What it means is, whenever you make a discovery, you always think that you have made a very unique and a novel discovery, but after you discuss with your attorney and all, you come to know that okay, there are similar or overlapping inventions that are there already existing in the world. So if you want to patent, then you should be able to say that mine is so unique that this does not match with this doesn't actually is not similar to that. So that process you have to take. So once you apply with an IDF, that means invention disclosure form, then the process you will involve all these steps. So once due diligence is done and actually it is given to the IPR cell, so we have to wait for the approval, because somebody has to take it further, and you know any patenting process will cost you a lot. I mean anything between 50 to 60,000. So somebody has to invest it. So if IPR cell is investing it, then it will think before actually applying it, because money is a scarce resource. So when this is actually happening, there is a waiting period, awaiting for the approval for filing. So some committee within an IPR cell or within Dean R&D or within an institution will make decision. Okay. If the approval is yes, that means if institution feels that the discovery made by my faculty or my research is good enough, a provisional application filed after execution of patent assignment agreement. So what happens is a provisional application is filed after execution of patent agreement assignment. So this probably you will remember in a previous class, I mean in a session I told you that there is a policy which says that who is involved in a patent process. For example, if you are a scholar, then if you're an institution you are working, and if you are using a funding, then you have to write, I mean you have to create an agreement between your funding agency, your college and the researcher. That is what is written in this assignment agreement. And then a commercial due diligence and then tech transfer attempt initiated from the IPR cell, keeping investigator in the loop. So what it means is, once there is a chance of going for patentable, the IPR will start certain processes. What it says is this patent is commercially useful, then it will start exploring the market. Or it will also check that if we are not going to explore this commercially, are there any possibilities that somebody else needs your this invention? That's called technology transfer. That is also taken care. And once that is done, then drafting and filling prosecution is taken. That means once IDF come into existence, then somebody has to draft it. Like, so these are my inventions, these are my features, this is what I'm going to claim and all. That is what is done. So assuming that somebody has submitted an IDF, then a decision is taken. If the decision is yes, that means I should proceed, then it goes like this way. So many a times, what are the key aspects? The key aspects, so when an inventor submits that, he has to explain all this, explain how the invention is technically distinct from and superior to the state of the art. So first job and the foremost job of an inventor is to explain this. And what competitive advantage does this invention provide? For example, you may have invented a mechanism where actually for a 1 liter of petrol it will give 300 kilometers. That's called competitive advantage. Or if you developed an algorithm where actually it will run the process 10 times faster, so that is a competitive advantage. And how the invention is performed, that means what was the context under which actually you did this. So once the people are convinced, then they will go further. But there is every chance that for some reason IPR cell will feel that okay, this is not worth patenting. In that case, application is not filed. That means the inventor will be called and he will be told that, see, the college or the IPR cell is decided not to go further with your patenting process. That means college will not be doing that. The individual may decide to file as an individual and request waiver from the college. So in that case, for example, still the individual inventor may feel that his patent is worth patentable, I mean his idea is worth and patentable. In that case, what actually happens is college will give permission to him, saying that kindly go ahead, we will not claim anything, we will not support you. So whenever there is an application, there are two possibilities. If the yes, then the process of application will go, otherwise it will be stopped at that level. So any question at this point of time? So what I covered is actually the patent process, where actually somebody makes a discovery and he will fill an invention disclosure form. Based on that, a due decision is taken by the IPR cell whether to go ahead for patenting or not. If it is go ahead, then a couple of things like commercialization and technical transfer opportunities are taken care, and then agreement is made between all the people concerned. If the answer is no, then the inventor is requested to come, and he is told that college or institution is not going to go for the patenting, and but he is free to do that kind of a patenting. So any question?
No question yet, sir.
Sir?
No question yet, sir.
Okay. I will go further. Okay. Now that I have established a context like what happens in an IPR cell and why it should be created within an institution, let me get into the core IPR cell. So whenever you want to develop an IPR cell or set up an IPR cell, there are certain requirements. What are the requirements? A physical infrastructure. That means you need a big room, a room or a kind of a building where actually you can set up your IPR cell. Then you need information resources, because I told you, so this patent is actually a techno, legal and commercial thing. So you need technological information, you need commercial information, you also need legal information. There are many magazines, there are many databases that you take care, and record keeping. Since this is a legal process, you have to maintain your documents clearly. For that, record keeping is also an important thing. And there is also a database. This database is all about whenever an application comes for a invention, then you must ascertain that this invention is truly new. For that, you have to check with the existing databases of patents. That is what you needed. That means that means because the inventor is the best person to know his invention and describe, he has to describe that. Identification, the full scope of the invention. That means now that you have made an invention, where it can be used. So that is called full scope. Explore the meets and bounds. That means what are the context in which actually your IPR, your invention will work, what are its limitations. Okay, all this is taken care in the disclosure. So in order to make it systematic, there will be a form called disclosure form. So inventor was enablers. So inventor in contribution to a solution of a problem. Inventor, enabler, no inventive contribution. See, in a group of researchers, actually, one may end up with getting the idea and other people might have helped them. So other people who have helped, they are called enablers, and the person actually who has discovered that core idea is called inventor. So look at this: inventor details, full technical description, extension and other application, where else it can be used, planned public disclosure, okay, funder details, like if you have got a fund from Indian government, then you are mentioning that, and all those things. So this is the first step process which to be taken care by an IPR cell. So in order to do this, you must have a facility. On the screen you can see that you need a separate meeting room, so that you can conduct it without disturbance, and internet connectivity, because I told you to either to get connected to an expert or to search one. Teleconferencing facility, because you want to get connected to other people. Easy availability of all related documents. What it means is, if you if you want to refer to a particular existing patent data, they must be available. So this is the physical infrastructure that you need. So at the end of an invention meeting, disclosure meeting, you know that there is a form which is filled by that, and that's a legal document. That means that would be basis for anything and everything that would happen. Whether you want to apply for a patent, then that will become a basis. Or if you want to make it a technical transfer, then that becomes your base document. So patents are paralegal document. That means they have a legal status. So signed copies are valuable in court proceedings and commercialization. So if you want to sell your idea, then the first thing they will ask you, how do you know that, man, how do I know that you are the owner of that? So any disclosed document like record keeping will help you. Okay. So each applicant is given a serial number, same as the electronics record, file and separate files with those corresponding serial number, each one. I told you, legally it will take between 3 to 5 years to get a patent. So you've got somebody has to maintain those documents. So for that, you have to have a separate record keeping room where actually you arrange them according to some rules, so that accessing, recovering, searching them becomes very easy. So what are the other, this is the core activity of a patent cell or an IPR cell. But what are the other activities? I told you, one of the challenges in an engineering colleges, most people will not be knowing IPR. They will not be knowing the procedures for that. So other activities of IPR cell will also include IPR awareness and promotion. That means you should create excuse me, awareness about IPR process and the very existence of an IPR cell, and promotion. That means you should do this so that it will benefit all the institutions. And you should also give research support. Somebody comes with a faint idea that I think this can be patentable, then you should support with the research saying that yes, it is possible to patent, or no, it is something which overlaps an existing thing. And agreements, this also have to help a researcher, because researcher's strength is the research, not getting into agreement and all, policy and all other mechanisms. So now interaction question. Anytime, any questions, sir?
No question, sir.
No question, I'll proceed. Okay. So now that I have told you the policy, then I'll come to the next step. Okay. Databases. Today we are living in information technology era where everything is available as information and databases. See, one of the challenges of a patenting process is that how do you find out that you have made a unique contribution? Because millions of people every day will be generating so many ideas, applying for patent and all. For that reason, actually, a patent office must have a great database access. What it means is, the moment somebody comes with an idea, a patentable idea, you should check into existing databases and find out whether it is really unique or it overlaps with an existing idea. So for that, you have to access databases. So in the beginning stages, actually, there are free databases which are available. For example, Google Scholar will give you access to most of the research papers published in the conference to check whether your idea is unique. Or it also, Google Patent Search will give you a place where actually you can search for the existing patents. So these are all the free databases which you can use. But if you go on high end and if you make really a great invention, and if it is in the field of say medicine or pharmacy or dental, then the free databases may not be able to give you enough search so that you can find out whether it is unique or not. For that, there are paid databases. For example, you have Scopus, which is a paid one, and if you have ChemSpider, especially for chemical engineering, searching patent literature, Delphion, Derwent, and if you are specifically searching for the Indian patents, then you have this india.bigpatent.org. So any question at this point of time?
No, sir.
Okay, fine. So the conclusion is this: IPR is to set up a facility for help process within an institution. So in the first session, we realized that IPR is an important thing, and second, we actually made a policy for that. And in the third session, actually, we made a decision to set up an IPR cell, and IPR cell is set up a facility to manage this IPR process. It helps researchers and students and faculty to discover IP potential within their work. So you have to educate them. So there is a chance of you ending up with discovering something. And this is the job of a IPR cell. And once they find that, then helping them in the process of getting into agreement, getting into published, and all those things. So this is a reference that I have used. Okay, and this is my contact information. And here I conclude my session.
Can you please revert to the slide where all the patents related websites are listed?
Where all the
Patents related websites.
here it is. So if you need a free search kind of a thing, if you are an amateur or if you are starting an IPR cell like my college, then going for a paid database is an expensive proposition. So if you want to go with initial search and all, so this is a slide which gives you all the free search. For example, see, normally a patent is created within a research context, and normally there are research papers submitted in the conferences and all. So if you want to search those papers, then Google Scholar will help you a lot. And if you want to search a patent itself, patent data itself, Google Patent Search is available, which is free of cost and which can give you a fairly good amount of search depth for you. And these are the free search sites. And if you go to a very advanced stage where actually you have made a very unique contribution kind of a thing, then if you want to ensure that there is no overlapping and all, and this is a paid database. Now, is this the page that the audience wanted?
Yeah, previous to the database page.
Which one, sir? Now I'm going from all the slides. Just I ask him to identify this one. This one. Is this one?
Just go back, sir. Before this database, the page it says database paid. The one before that.
This is paid.
The one before this one.
This is paid, sir.
Before this one.
Free.
Yes, sir. This one. That free one.
This one?
Yes, sir.
Okay. So any more questions?
No, sir. Those are all the questions.
Okay. Fine, sir.
Okay, sir. Thank you, sir.
Okay. Thank you very much.